That is not what this is about. The reason the government has accommodated the Labor Party's wishes here, which were raised very late in the piece, I might say, and after the matter had been thoroughly looked at not once but twice by the Parliament's Intelligence Committee, is merely to remove an obstacle which had been thrown up at the last minute by the Labor Party to getting bipartisan support. This has never been about journalists. What this has been about is creating a statutory obligation to retain metadata, which is already retained by telecommunications companies, but which, with changing technology, changing billing practices, was no longer being retained. So an existing investigative capability was being degraded.
Well, why not give journalists an exemption then?
I don't think journalists should be above the law, but that having been said, we have recognised for some time in this country now that the protection of journalist sources is something that the law ought to acknowledge. So what we don't think that this was really necessary because, as I said in answer to your earlier question, this was never about journalists. This was about law enforcement and national security. But in order to put minds at rest that this could affect journalists, we have agreed to create a limited exemption in relation to them.
Okay, the MEAA, the Journalists' Union, says that even with the changes, the law still permits an outrageous attack on press freedom.
That is outrageous hyperbole. Well, there is no. Let me address what the MEAA has said. This law does not change the status quo. That's the first point to be made. Telecommunications companies have always retained this information. It has always been accessible to ASIO, to state and federal law enforcement authorities without warrant. At heart, all this legislation does is to mandate the continuation of the status quo, but it also builds in new protections, new privacy protections that weren't there aren't part of the existing law. Let me mention three of them. First of all, the number of agencies, the number of government bodies that can get access to metadata has been reduced from some 80 to about 20. So it is now limited only to ASIO, the police forces, state corruption bodies, and the three big economic regulators, the ACCC, ASIC, and the ATO. Secondly, we've discussed the new protection for journalists that is not part of the existing law. And thirdly, under the legislation that the government seeks to pass this fortnight, there is a new oversight power held by the Commonwealth Ombudsman that wasn't there under the pre-existing law. So these are three new privacy measures that weren't part of the pre-existing law.
But you can still get a warrant to get access to journalist metadata, can't you?
At the moment, you don't need a warrant to do that.
No, but essentially you will be able to get one, which won't be too difficult.
And in the unlikely event that such a warrant was sought, there are protections built into the legislation to protect the journalist source. But I come back to Michael, I come back to my initial proposition. I don't think many people in the community would say that journalists should be entirely immune from criminal law investigation, so that in the unlikely event a journalist or the source of a journalist were actually involved in the commission of a crime, of course they should be able to be pursued.
I don't think the Media Alliance is arguing that, or any other journalist would argue
in the quote you just gave me seemed to say there should be a blanket exemption. But of course there shouldn't be a blanket exemption.
Why not consider some provisions such as the ones that the US has put in place, where warrants are only issued as a last resort after all other options have been exhausted, and media organisations have been given an opportunity to argue before a judge why a warrant should not be issued. Why not do something similar?
It has never been the case in our system that warrants that a party against whom a warrant sought is given advance notice of the warrant. The warrant process is an application to the court or to the tribunal, or in unusual circumstances.
Okay, but should media organisations be given an opportunity to argue their case?
Media organisations are not the target of this law. The target of this law are criminals and pedophiles and terrorists. I regret that the debate about this law has diverted down this path about journalists, for heaven's sake. Journalists are not the object of the law. This is a law that continues to guarantee the availability to the police, to the law enforcement and national security authorities, essential evidence in criminal and terrorism investigations.
Okay, how do you define a journalist? Because I mean that definition is pretty wide now. Are bloggers covered, for instance?
I wouldn't regard bloggers as journalists. I would regard, Michael, you as a journalist. And there are various statutory definitions of journalism in Commonwealth law at the moment, by the way. But a journalist is, for the purposes of this law, a person engaged in the profession of journalism. And there is an interesting argument, of course, as to what at the margins a journalist is. Ultimately, that is an issue resolvable by courts, just as the question of what a member of another profession may be, who is within and without the definition, is ultimately resolvable by courts. But for the purposes of this discussion, a journalist is a person engaged in the profession of journalism.
Okay, can I just ask you quickly about some other areas of concern about the national security legislation coming from the Muslim community in particular? They say that some of them say that they are a key target, and that some Muslim leaders say the government's hardline approach is alienating Muslim youth. Now, I'm sure you wouldn't describe Jamal Rifi as anything but a moderate voice in the Muslim community, and he says that the community has yet to see any of the money you've pledged to tackle extremism.
Well, that's not... I've got a lot of respect for Dr. Rifi. I think Dr. Rifi's contributions to the public discussion of these issues has been thoroughly constructive, but on this particular occasion, he's not right. The government has several programs which have been rolled out and are in the course of being rolled out among the community, and that money has begun to flow. I myself have been involved in the authorisation of grants to members of the particular Muslim community organisations. So I can assure you that Dr. Rifi may be expressing a wish that the approval process happened more expeditiously, but it's not right to say that the money has not begun to flow. It has.
Okay. Attorney General, we'll leave it there. Thanks very much for joining us.
Thank you very much, Michael.